Welcome to Bootleg Legal. My name is Heather, and this is the first lesson of your course. We're going to talk about entity choice. Do you need to be an entity? What kind of entity should you be? How hard is it? How expensive is it? And does being an entity really protect you? Okay, the short answer, yes, it protects you. And the short answer is also that most businesses would probably benefit from being an LLC, a limited liability company. But let's back up. What is an entity? So you have, if you're operating your right now on the street, your business, and you have not filed anything with the state, you are a sole proprietorship. If you are operating on the street and you have a business partner, you are a general partnership. Neither of these types of businesses have any liability to protection. This means that if somebody sues you for anything, they can come after your personal assets. That seems like a bad idea, right? So then we get into the state-filed entities, which are corporations, whether S Corp or C Corp, limited liability companies, LLCs, and then there's a few other types of entities that aren't really used anymore because the LLC sort of came up and just erased the need for them, like LLPs and other things. There's also professional corporations. If you are a type of business that is required to file a professional corporation, lawyers, maybe doctors, depending on your state. But we're going to focus on corporation versus LLC. So a corporation and an LLC have identical corporate shields, equally strong. No benefit going in one direction or the other. Both corporations and LLCs can use an S election for tax filing so that you don't have double taxation. And both of them have to use a C election when you have a foreign investor or you have an entity owner or you have more than 100 shareholders. That's really something to discuss with your CPA, but on the protection front and on the tax front, you can get similar treatment, if not identical treatment, from either an LLC or a corporation. So it brings us down to what's the real big difference? Well, corporate law is much more structured. Some states more than others. California is the most protective of shareholders. Delaware is the least protective of shareholders and the most protective of managers. And every other state falls somewhere in between. And being an LLC gives you a lot more flexibility because the laws governing an LLC are sort of a hybrid between a corporation and a partnership. It's like they had a baby. And so corporations are more fluid because it's presumed that they're going to own their own company, that they're running on a day-to-day basis, where with corporations, it's assumed there's going to be a bunch of investors and then other people are going to be running the corporation, sort of a little bit of a divorce between ownership and management. So because of that, because LLC is this love child of partnerships and corporations, there's a whole lot more flexibility. You get to set up your company to run it the way that you want to run it. You can say, we never have to do annual shareholder meetings or member meetings as they would be, and we don't need to do resolutions, and we don't need to do this. In fact, you can just eliminate a lot of the corporate maintenance that you can't eliminate if you're a corporation. If you're a corporation, you're doing your annual meetings, or you should be, and you should be keeping up to date with all of your corporate formalities. You can just erase that requirement if you become an LLC. You can also really set up the structure and the authority of your managing member or your members if they're managing all together. You can say for, amounts of money over $5,000, you need majority approval. For anything smaller, any manager can spend that. You can set up dispute resolution mechanism. You can set up buyouts, mandatory buy-sell agreements. So there's so much that you can do when you're a limited liability company, but because it's so flexible, there's also a lot more to mess up. So I'm going to say if you are forming a single member LLC, feel free to do it on your own. You can have a lawyer do it if you just don't want to bother and you want to make sure everything's done right the first time. Fine. If you have multiple partners, you absolutely need to have a lawyer draft your LLC agreement, your operating agreement. I have litigated many business divorces. They are as ugly as actual divorces. They can go on for years. One of the ones that I litigated cost each side over $300,000 in legal and expert fees to basically break up this company. My client had signed an operating agreement drafted by his partners at counsel, and he never had his own counsel look at it, and it was a terrible agreement for him. I've seen many other partnerships where they come to me at a point where, or my client, will be one half of the partnership or the LLC, and will say, I always thought this was our understanding of how we were going to operate and share profits and share management authority. And then the other person genuinely has different understanding of what this business was going to be and who was going to be in charge. And these things can be resolved if you actually sit down and do the work and make sure that you get an operating agreement really reflective of both parties' intentions. And you really do need a lawyer. I mean, the best case scenario, if you had the money, would be that you each had your own lawyer in the drafting of this operating agreement. But even if you have to share a lawyer and sign conflict waivers, that's still better than not having a lawyer at all. In fact, it's so much better. Make sure, obviously, it's a lawyer that knows, is very familiar with the LLC law of your state. But yeah, so I advocate that most parties should probably be an LLC, most companies. There are, even 5 or 10 years ago, it was said that there were some venture capital investors and other investors, even some angel investors, who just strongly preferred the corporate structure because shares seemed more fungible and movable than membership interests, which were typically represented by percentages. However, that's pretty much gone away or gone down a lot over the last 5 to 10 years. A lot of investors are now perfectly comfortable with you being an LLC. And you can even set up units that reflect shares so that it's not just membership percentages, which is what sort of they were hesitant about before. A lot of people just now recognize that the LLC is often a better investment mechanism, and it's an easier one to maintain because, and here's the drawback, if you have a corporation and you don't maintain your corporate formalities, you don't do your shareholder meetings, your board resolutions, your shareholder resolutions, blah, blah, blah. You don't do that stuff, and down the road, somebody wants to what we call pierce the corporate veil, right? They want to come after you and get your personal assets or the assets of another related business. If you haven't maintained any of your corporate formalities, that's sort of like one strike against you in their pursuit of piercing the corporate veil. It's not going to guarantee that they're going to get there. They're going to need other factors as well, but it's one of them. So why give that to them? If you have a corporation, you're going to have to do the corporate maintenance. If you have an LLC, you can set it up so that you don't have to. And let's say you set up an LLC, but down the road you do want to attract venture or angel investment. Well, the time that you can save over the first 3 to 5 years of your business maintaining all those corporate formalities could basically end up equaling the amount it would cost you to convert from an LLC to a corporation down the road if you had to do it for a particular set of investors. Okay, so it's not even the end of the world if that happens. So long story short, if you have any personal assets of your own, you should probably not operate your business as a sole proprietor or as a general partnership. If you have them, you should operate as a corporation, professional corporation, or a limited liability company. All other things being equal, a limited liability company, I believe, is the better vehicle for most businesses, maybe not all, but most businesses, because number one, it's much more flexible, and number two, it has a lot less maintenance requirements than running your business as a corporation.